While this lawsuit questions the actions of the ATF, the events actually start all the way back in 1968. The Gun Control Act of 1968, called GCA, requires those engaged in importing, manufacturing, or dealing in firearms to obtain federal licenses, keep sales records, and conduct background checks, and mark their products with serial numbers. Well, the case was filed in 2023. It really begins with the Gun Control Act of 1968. However, what Justice Gorsuch stated in the opinion about what the law says is not exactly correct. The Gun Control Act reads, "It shall be unlawful for any person except a licensed importer, licensed manufacturer, or licensed dealer to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce, or except a licensed importer or licensed manufacturer to engage in the business of importing or manufacturing ammunition, or in the course of such business to ship, transport, or receive any ammunition in interstate or foreign commerce." You see, the Gun Control Act only prohibits a person from participating in certain forms of interstate commerce. As defined in the GCA, the term interstate or foreign commerce includes commerce between any place in a state and any place outside of that state, or within a possession of the United States, not including the Canal Zone, or the District of Columbia, but such terms does not include commerce between places within the same state, but through any place outside of that state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States, not including the Canal Zone. Now, this is allowed because Congress has the authority under the Constitution to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Act also defines a firearm as the term firearm means any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, or any firearm muffler or firearm silencer, or any destructive device. Such terms do not include an antique firearm. Now, why did Congress pass this legislation? Shortly after the assassination of Senator Robert F. Kennedy and Dr. Martin Luther King Jr. stunned the nation, Congress adopted the Gun Control Act of 1968, the GCA. Existing gun control measures, Congress found, allowed criminals to acquire legally untraceable guns too easily. Once again, Congress exceeds its constitutional authority because it saw a need and thought it knew better than the Founding Fathers. In response, Congress adopted a number of new mandates. As a result, many of those now engaged in importing, manufacturing, or dealing in firearms must obtain federal licenses, keep records of their sales, and conduct background checks before transferring firearms to private buyers. And the Act also requires importers and manufacturers to mark their firearms with serial numbers. Again, the Supreme Court reads into the law language that does not exist, because that language of the law only impacts any firearm in interstate or foreign commerce. These mandates serve at least two ends. The background check requirement seeks to keep guns out of the hands of criminals. The problem is, just because Congress thinks keeping a gun out of the hands of criminals is a good thing, which I tend to agree with, that doesn't mean they can break the law to do so.